I walk into like a corner store and I want like a Coke, and I pull the Coke, a Coke off the shelf, and it's got the label on it. I know that's like an authentic Coca-Cola product. And it's not a knockoff, and it's not Pepsi, and it's not something else. It's for me to know so that I can distinguish between different choices in the marketplace. In the United States, your rights in a trademark, they actually just magically arise as soon as you start offering the goods or services. So we'll talk about the registration process for trademarks a little bit later. There is something called the United States Patent and Trademark Office where you can go and you can register your trademark nationally. There's a lot of good reasons to do that. But also, just think about all the various, restaurants, small businesses that they have a logo and they start using them locally. Those businesses actually gain rights to whatever that logo is, whatever the brand name is, as soon as they start using it and start offering it for sale, offering goods and services under that logo for sale. So that's not true in other parts of the world, but it's true here. All right, so we're not gonna really focus a ton on patents. I am a registered patent attorney. I feel like I kind of have to just, go through patents a little bit because they are a really important part of intellectual property law. They protect new and useful processes, machines, manufacturers, compositions of matter, or any improvements thereto or thereof. They also don't cover like abstract ideas. That would cover mathematics, for instance. Pretty much all abstract ideas, laws of nature, natural phenomena. This right here is the Manual of Patent Examination and Practice. This is basically the book, now available electronically, that dictates how the United States Patent and Trademark Office handles patent applications. So anyways, patents are really important to a huge part of our economy in the sciences, technology, all of that. However, from a comic book perspective, from a media company's perspective, patents are not necessarily the main event. Trade secrets. So this is the last big type of intellectual property, and it is like the most expansive. As you can see, it covers really any kind of secret, basically any kind of knowledge. Blah, blah, blah. I mean, you can just read them yourself. The real key here is you have to derive independent economic value from that information being maintained as secret. So it's one of those things that anything that I might have as a company that I keep secret, that gives me some kind of competitive advantage over my peers, over my rivals. As long as I keep it secret, it's protectable as a trade secret. And so, like I said, that could be anything from if you think about all of the designs for, Epic Universe, before it was released, before they started building, all those designs would have been maintained under secrecy. They would have been maintained as trade secrets. And if someone had tried to steal them, Six Flags or Disney or whoever, Universal would have had a cause of action against them for misappropriation of trade secrets. So that's just one example. Your plans to release a series of comic books or negotiations between, say, a movie studio and an author. Lots of things like that could potentially fall under trade secrets. And if somebody was to, in effect, steal them, it could be a big problem. All right, so we've talked a little bit about what these types of intellectual property are. So let's talk a little bit about how long they last. So copyrights last a long time. Author plus 70 years. So for anything that you might write as an author, as an illustrator, your painter, it's basically throughout your entire life plus 70 years. Now, 95 years first publication, 20 years, 120 years from creation for works made for hire. We're going to talk about that because that comes up a lot just in the context of employer-employee relationships. And also if you're a contractor, imagine if anyone's out there as a graphic designer or something like that, you sign a lot of agreements where the work that you do is considered work made for hire. We'll talk a little bit more about that. Trademarks. So trademarks can last forever in the United States, provided you keep on using your trademark in commerce. So I don't know when Coca-Cola registered, the Coca-Cola name, the little swirl or whatever, but as long as they keep on using it in the market and they basically take a check-in every 10 years with the USPTO and pay them more money and file some paperwork, they just keep that forever. So trademarks can be really, really powerful because, like I said, you can keep them going. So intellectual property patents. So typically, I just want to get this out of the way. I do think it's important to kind of know a little bit about everything. 20 years now is how long a patent lasts from the date that it was first filed, let's just say in the United States. Things can get a lot more complicated than that, but that's a good idea just to have in mind. So if you hear about like, pharmaceuticals going off patent, that's because 20 years, basically 20 years has run since they were first filed. That first application was filed at the USPTO. Design patents, which cover ornamental designs, basically non-utility designs, now last 15 years. Trade secrets, and again, another thing that's really powerful about trade secrets is that as long as you maintain their secrecy, they last forever. So the recipe for Coke is probably, it's well over 100 years now, and it's still a trade secret. And the reason is because it's still secret, and Coke makes a lot of Coke off of it. So there are some other types of intellectual property that should not be overlooked, and you can tell probably by some of these that these are like very, very important. And they're important if you're starting, like if you're an artist or a creator yourself, you're trying to get your work out. One of the first things you're probably going to do is get an internet domain so that you have a website where you can post your work. Well, once your work kind of gains traction and people start reading your stuff, they start maybe buying things, the value of that domain goes up. And so it becomes valuable intellectual property. Social media accounts, same basic reason. I'm sure a lot of you out there you could be on TikTok and Instagram like right now. Anyway, social media accounts can be really valuable too, and they're treated in effect as a type of intellectual property. I always just want to flag for people that as new technologies arise, new types of intellectual property can arise with them. So, 25 years ago, we really didn't have social media accounts. 40 years ago, there really wasn't internet domains, but those are like super important now. Maybe in the future, certain storefronts or avatars or other things in like a metaverse could be really, really valuable. And that means that, again, if you're creating a world, and this is one of the major outlets, like being, having a virtual storefront on the metaverse, it's important to know that you have certain rights to that. All right, so securing your intellectual property. One of the things that people oftentimes don't do, and I run across this like in the pro bono work that I do, and also in just like the paid work that I do for my clients, is that they think they own something, but they really don't. And that's because in the United States, most intellectual property law or property rights, it starts with a human being, it starts with an individual. And so if you're a business, you need to like do things to get those rights from whoever you probably paid to provide that work to you. Also, if you're collaborating with a friend on something, it's important to know that like your friend might have some rights and you have some rights. And if you're gonna try to sell a comic book or something like that, you may need to take some extra steps to basically bring your rights together so you can release your work without any trouble. So, good news is you as the author will hold the rights to your copyright. So again, if you're just working yourself on a comic book or you're writing, a movie script or whatever, the rights belong to you basically because you're the creator. However, like I said, a lot of times we collaborate with people. And sometimes we don't even think about it in like a business sense or a legal sense. So like friends and relatives, contractors and employees, of course, can all contribute intellectual property. Some things that people think of as kind of like, innocuous, but if they're really going to make something that's going to be developed and released commercially, they need to be aware of. It's like you can imagine, like I'm not really good at drawing, so if I was creating a comic book, I would need somebody to provide the illustrations. And imagine if I just had like my friend basically provide the illustrations. Well, my friend has the intellectual property rights, the copyrights to those illustrations, and I have the copyrights basically to the words. We now need to like do something to bring them together. Same thing with like a relative, and you can imagine if you're like hiring people. Okay. So at a high level, we'll talk about the exceptions. You always need a written agreement to transfer intellectual property rights. So this is like good news for you, like people who are out there that like maybe you earn your living through like graphic design work, or maybe you do advertising for people. There's any number of different ways that you might be able to contribute, or as like part of your job, you're basically generating something new that is protectable. And a lot of times, and I say this because my sister is an author, and she also does a lot of these like contract works for like just people all over the country. You know, one of the key things for her is she wants to protect her own work. There's certain work that she does not want to sell. And then she's okay like helping other people out, like, you know, helping them on like their projects. And so, you know, you always need to make sure you have a nice, you know, really, really clear line between those two things. And the good news to know is that you're not just going to be able to, like, no one's going to be able to, like, secretly or sneakily, like, seize the work that you're protecting, because you're going to have some kind of intellectual property assignment to actually transfer the rights in that work over to the counterparty. And that's going to be in a standalone agreement, an employment agreement, or like I said, my sister does a lot of contractor work. So a lot of the things that she writes, or a lot of the things that she does, fall under contractor agreements or independent contractor agreements or like developer agreements, things like that. There's also this doctrine called work made for hire that is also really important in the contractor context and in the employee context. Okay, so this is what a typical intellectual property assignment clause looks like, and I know there's a lot of language here. So I'm just going to try to focus on a couple of the really big like points. First of all, works made for hire. So unless you're an employee, and that means like you're like a regular employee, you show up to work, you know, you get paid pretty regularly, direct deposit, that type of stuff. You know, you have a, you know, it's your job. If you're not that, for the works made for hire to actually apply to you, there needs to be something that says, like, to the extent that the artwork does not, you know, contractor agrees that all our work are works made for hire, and the company is the author. It's going to have to be something like this, but the bottom line is those words, works made for hire, have to show up. Then, because works made for hire, we'll talk about this, only applies to copyrights in the United States, you have to have what's called an assignment clause. And frankly, the word assign should be used, but it's going to be like hereby transfer or assign. Contractor hereby irrevocably and unconditionally assigns the company all right, title, and interest. And then you'll see I've highlighted some of these words, artwork and intellectual property there too. I'll talk about why they're capitalized, and I'll talk about why I like, you know, they're in different colors. And then down here, you'll see that there is contractor hereby grants company blah 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 an exclusive, royalty-free, irrevocable, perpetual, worldwide license. The key word is license, and then there's some stuff that says like what's the license to? What can you do with this license? And it's make, modify, use, create derivative work, blah 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 of the artwork. So now we're going to try to break this down a little bit. So like I said, work made for hire came first because it's really, really important, and it's a very powerful tool for transferring or for acknowledging who owns the intellectual property. But just keep in mind, it's really powerful, but it only operates in two contexts. So employee, so if you're an employee and you're working within the terms of your employment, everything that you do for your company within the scope of your employment, work made for hire, your company owns that. So like if I worked for an advertising agency and I basically showed up to work 8 to 5 every single day, all the everything that I write basically just is owned by the company. Or it can be this work specially, you know, ordered, blah blah blah. I just want to focus on what's underlined here. Parties expressly agree and written instruments signed by them. That just means it has to be in writing. That it's a work made for hire, and the words work made for hire have to be there. Again, this applies to copyrights, so it doesn't apply to patents, it doesn't apply to trademarks, it doesn't apply to trade secrets, it doesn't apply to internet domains, just copyrights. There's a couple other little things. that are down there that are important to me, less probably important to most of the people in this room. But just remember, it's copyrightable works, it's not trademarks, it's not other things. So if it's not a copyright and it's not a work made for hire, how does the rights to something transfer from the original author or the original creator to, say, a business or somebody else, you know? Well, through an assignment clause. This does apply to everything. Everything, ownership and intellectual property, no matter what the intellectual property is, can be transferred with an assignment clause. It must include present tense assignment language. Any other type of language, so present tense is I hereby assign. Everything else doesn't work. So like I will assign, I shall assign, I should assign. None of that stuff actually transfers ownership. It always has to be present tense. And then you don't have to gain rights to intellectual property, you don't have to own it. You can actually get, just rights to do certain things with intellectual property. So this is the difference between, I'm buying a house versus I'm renting a house for a certain period of time. And so lots of people, lots of companies either license intellectual property from another company or another person, or they basically license out intellectual property to another party. So you can think about it like this, like J.K. Rowling, for instance, she owns her copyrights, but she licenses the copyrights in her work, Harry Potter and all that, to Universal Studios. She has Broadway shows that are put on by production companies in New York and in London and stuff like that. She's giving those people rights. Those rights, typically, they're limited. She still owns the copyrights, and they're typically called licenses. And the ownership still stays with the original party in that regard. So definitions. So this is why I had all those highlighted terms. If you ever are presented with a contract, for intellectual property rights, you should probably have an attorney look over it. However, I know that that's not always feasible. And so a way to understand how contracts are written is that there's lots of defined terms, and they're always capitalized. And they're defined somewhere. Sometimes they're defined in the front, sometimes they're defined in the back, sometimes they're just defined throughout, and they will actually typically have quotations around them, and it'll say artwork is, and it'll say, artwork shall mean, the drawings, cover arts, illustrations, etc., developed by, artists under this agreement or something like that. Or there'll be a schedule in the back that basically says exactly what the artwork is, Company, that's typically going to be defined at the very top. It could be XYZ Corp, the company. And then contractor, again, for creative agreements, oftentimes that's going to be artist, it could be illustrator, it could be, filmmaker, any number of different terms can be used. But in general, whoever is commissioning the work is going to want to have ownership over whatever the physical manifestation is, like the physical sketches, the physical designs, whatever. And then they're going to want to have the intellectual property rights in those physical designs, whatever, sketches and whatnot. Okay, so, again, a lot of things just kind of magically happen to you as you're creating your art, or as you're creating a new, a new story or new whatever. However, there are advantages to actually formally, basically, securing your rights. It allows you to basically bring a lawsuit. So when you hear about somebody, and this happens every once in a while, like in Hollywood. I work with a lot of software companies, so I hear about it a lot in the tech area, but it could happen anywhere. When people have their ideas stolen, the way they push back, the way they fight back, is they basically say, those are my intellectual property rights, and you're using them without my permission. I'm now going to sue you for intellectual property infringement. So registration is oftentimes the first step in being able to do that. It gives you certain damages and all these other things that you can ask for. These are like basically in the applicable law, the United States Code for most of this. And also one of the other things that's nice about like the copyright registry at the United States Copyright Office, the patent registry, the trademark registry at the United States Patent and Trademark Office, is that these are all freely searchable databases. And someone can like basically search for something like a trademark and immediately see, oh, so-and-so owns that, or such and such company owns that. Same thing, like if you wanted to like, look up like who owns, the copyright in Harry Potter and the Sorcerer's Stone, you could actually go to the United States Copyright Office, search for that, and you're gonna see that it's either J.K. Rowling herself or her company that she owns. And so that like puts, what we say in law, it puts people on notice, but what it basically does is it just means that like I've told the world that I own this. And other countries have similar systems, but the United States is typically the largest, so that's where we are, so we'll stay focused on the US. You have all sorts of rights when you're the copyright holder, so I keep on coming back to like Harry Potter and J.K. Rowling. But you can basically, you have the right to reproduce and prevent people from reproducing your work. Preparing derivative works, what this means is think about like sequels. Think about taking a book and making a movie out of it. Think about taking a book and making like a Broadway show out of it. Think about taking a book and like making a world, at like, Universal Studios. Those are all examples of derivative works. It allows you to distribute copies. Phono records basically are like, for those of us maybe a little bit older in this room, you used to be able to buy records, buy tapes, buy CDs, buy DVDs. Phono records are going to cover that. You can also basically perform the work. So think about things like plays and Broadway shows. Also performance could basically mean something like publicly performing, showing like a movie or something like that. And then sound recordings perform the copyright work publicly by means of digital audio transmission. So that's like a very specific thing for music. So these are all like, if you think about it, this is pretty much what you can do with like basically works of art. You get to show it, you get to create like other works off of it, you get to distribute it, you get to make like copies of it, all that type of stuff. Yes?
Before you had mentioned regarding the copyrights, if you do not have it, can you get it at the moment closer to when you say, you know what, that was mine before, I'm going to go ahead and register it?
Yep. So what you can do...
You didn't need it.
Yeah, so that happens all the time, by the way. So there are advantages, which we don't need to get into, about like either right before you publish a work or like right after you publish a work. If you go to the US Copyright Office and get that registration, that's advantageous to you. A lot of people don't do that. And when I say a lot of people, I mean a lot of companies, a lot of my clients, they don't do that. There is a way to expedite your copyright registration. You have to pay extra money for it at the Copyright Office. That like if you see someone stealing your work, you can basically be like, oh my goodness, I'm probably gonna have to sue that person. And so you can like rush your registration at the Copyright Office, get the copyright registration, now you've got your copyright registration, and now you basically go after that person. So there are like express ways, and it's not like you're completely just out of luck. But it is better to like right before you publish. Like imagine if you're like releasing like a comic book, you're releasing a book, you're gonna release a movie. It is better to basically, once it's finished, to essentially get the copyright on it. Yes, sir?
Yeah, I publish on Amazon.
Yep.
Am I covered with all this copyright stuff?
So, good question. So you create your own work? Like
yeah, I write, I'm an author, I write books and I publish them on Amazon.
Got it.
4 years.
Okay. So, my feeling is yes, because you wrote those.
Mm-hmm.
And I'm guessing that whatever the Amazon like terms are that allow you to basically like sell your works through Amazon, there is no Amazon's not interested in like sneakily getting your copyrights. I don't think they are.
No,
I haven't directly dealt with that, so I can't say for certain. But I also know that like I have dealt with other people who have distributed original works of art through Amazon, and I don't think that there's been any issues with the Amazon-like stuff.
Okay.
So what I would say though is it's kind of up to you to like make sure that like no one's like stealing your stuff, or like basically just like flat out ripping off your works and selling them somewhere else and not paying you. If that was to happen, you'd have to go ahead and like, again, you'd want to rush it at the United States Copyright Office, get that registration, basically, you know, filed, and then, you know, publicly available, so accepted by the United States Copyright Office, and then you'd want to go after those people.
Okay.
But yeah, but that's the beautiful thing about copyright law now is that you by like I'm assuming you're probably like typing on a computer.
Right.
As soon as you hit the save button, you have a copyright in that work.
Okay.
It used to not be that way before like 1978 or 1974. You used to have to do a bunch of stuff before you actually got the copyright in the United States, which means that lots of people inadvertently lost rights to their own works. That's been changed now. And also that's kind of a global policy, is that like by creating the work and then saving it, you have a copyright in that work. Okay, there's a huge exception to copyright law. And it's called fair use, and you've probably heard it before. This applies, and again, I'm ripping all this off, not ripping, but this is all basically a paraphrase of what's in the United States Copyright United States Copyright Act. Criticism, comment, news reporting, teaching, and scholarship. That's all examples of fair use. So if you think about it, when the New York Times publishes a review of a movie or a book, and they might quote something from it, or they might talk about characters in that, whoever owns that copyright in that movie or book can't come after the New York Times, because the New York Times is publishing criticism. But that doesn't get you all the way there. Basically, Congress has told courts that when weighing fair use, they have to look at these things. So, purpose and character of the use, whether such use is a commercial nature or for nonprofit educational purposes, nature of the copyrighted work, amount and substantiality and portion used, and effective use on the potential market. So just to go back to my criticism or review of like a movie or a book in like the New York Times. Well, the New York Times is very much a commercial. It's a commercial product. They make money, or they hope to make money by selling their newspapers. So that's not the end of the story. The nature of the copyrighted work is basically, we're talking about, let's just say it's a review of a novel. So the nature of the copyrighted work is a novel. The fair use is a critical review of the novel. So there are two different things. Amount and substantiality of the portion used. What this is basically saying is that if someone says, I am writing a criticism of, a certain novel, and I'm just going to republish basically the entirety of the novel or 80% of the novel, you're now like falling out of fair use. But if you think about like a 200-page novel might get like, a page in the New York Times, and so it's just using very little of the novel in the actual review. So that's the amount and substantiality section. And then the effective use on the potential market, this is like you're basically competing. It doesn't mean that if you write a bad review of a novel and say that the novel is terrible, you're no longer in the fair use world. No, it just means that, a newspaper with a review of a novel does not really directly compete for dollars with the actual novel itself. People buy newspapers for one reason, they buy a novel for another reason. So they're not really in competition with each other, which means that the review is not really directly competing. Where you do see this come up an awful lot is for musicians out there, when people are basically using, when they're mixing in certain existing music from other artists, when they're sampling music, that type of stuff, then this is where like courts will focus on this, because if the original work is essentially like being impacted in such a way that people are no longer buying the original work, they're getting like the remixed version or the sampled version, well, it's probably going to fall out of fair use. Fair use is like super complicated. There's lots of court cases about it. It's really there to protect Criticism, comment, news reporting, things of that nature. Criticism, though, could be like one artist making basically a statement about another artist. It's really about like maintaining a dialogue and making sure that people can essentially kind of have the right to their own free speech. But there's a lot of like gray area, and so some things that I've highlighted, like the movie review or like a news article, those are like super within the scope of fair use. Things like sampling of music typically will fall outside of fair use. Trademarks. All right. So trademarks are really, really important, like I said, to practically all businesses. Every business we can think of here basically has a trademark. It's the name of the business, it's the name of the products, the goods and services that they sell. While you don't need to register your trademarks, again, it's very helpful to register your trademarks with the United States Patent and Trademark Office. Typically, it's going to be necessary to bring a lawsuit in federal court. It's going to provide a basis for international registration. So think about it this way. Initially, I'm sure that the people that came up with like Batman, at DC Comics, were probably first and foremost thinking about the U.S. market. But as we all know, Batman is an international phenomenon. So, you do want to be able to have the ability to register abroad if necessary. And a U.S. registration at the United States Patent and Trademark Office gives you that basis. It again creates that record of ownership and the right to use. So there's lots of local stores which for a variety of reasons, probably don't need to register and they may not be able to register their trademark with the United States Patent and Trademark Office. And you can't necessarily know very easily who owns that name. It is pretty easy to find out who owns the trademark DC Comics. You can just go to the United States Patent and Trademark Office. They have a little search feature. You type in DC Comics, and it's going to tell you all the information, including a contact information, which is almost certainly going to be to the lawyer that represents DC Comics or its corporate parent. One thing about trademarks, and this is where, again, a lot of popular news coverage doesn't really make it very clear, is that a trademark gives you rights to use that trademark with respect to a certain set of goods and services. So I always use Nike in this regard. So Nike has the swoosh, the Nike swoosh, and it has the Nike name, and only Nike can use the swoosh and the Nike name when it comes to athletic shoes and running shoes, and when it comes to certain athletic apparel. However, Nike is the goddess of victory. I don't know if you know that, but because I do a bunch of trademark stuff, I learned that. People can use Nike in other contexts all the time. It's just not when they're trying to basically, market or sell, athletic shoes. And so it's important to understand that Apple's, again, a perfect example. Apple has the right to use the Apple logo and the Apple name with respect to computers, not necessarily with respect to chairs or whatever, clothing, for instance. So, but again, within that scope, within that set of goods and services, it's incredibly powerful. And again, if you have a trademark, what you can do is when you see, for instance, if Nike sees that people are selling knockoff Nikes, in the streets of New York or in downtown Miami, they can get an injunction for the defendant to stop doing that. They can require destruction and forfeiture. It kind of feeds into it's they can stop people from selling the knockoff goods. They can have those knockoff goods destroyed. They can of course get monetary relief, oftentimes called damages. There's other names under certain other circumstances. But long story short, they can get money from whoever is the counterfeiter. And then you can sometimes get plaintiff's attorney's fees. Just remember, when you're talking about courts fees, actually suing somebody in court, the attorney's fees can be in the hundreds of thousands, millions of dollars. So getting attorney's fees is it's another nice thing to be able to do if you have the trademark. Okay, other issues for artists and authors. So like I said, a lot of the stuff that I've talked about, definitely artists and creators need to be aware of, but a lot of other people need to be aware of too. This is stuff that really does come up if you're more of a creator, And I'm going to say, like, a creator could mean, like I said, illustrator, artist, novelist, but it could also be somebody who is like an influencer on social media. Or you may consider yourself an artist or like an illustrator, or you're creating comic book characters, but you're primarily posting that on social media. So things that you need to be aware of legally that could cause you some trouble is the right of publicity. So I'm going to focus on the state of Florida. Just understand, I'm also licensed in New York. I used to practice law up there. Some of the language and the terms change, but the same basic kind of behavior is dealt with in a similar way up in New York. So you have a right to publicity. That basically means that your image, your name, your image, your likeness, you might hear that if you're like a fan of sports like I am. You have the right to profit off of your name, image, and likeness. Other people don't have the right to just profit off your name, image, and likeness unless for advertising purposes. You know, to talk about, like, for instance, what a politician is doing. Resale of items where a person has consented to the initial use. This is just being clear that, yeah, if you give your consent, people can use your name and image. And then photographs when people are not otherwise named or identified. So that just means that, like, again, if you know that you're in a photograph, but no one else would know that, your right to publicity has not been violated. Defamation is another thing. This comes up again. Think of a context of social media or whatever, where people are talking about other people. So defamation is a publication of something that's false. The defendant, that's the person who's doing the defaming or alleged to be doing the defaming. Reckless disregard, or actually has knowledge that it is false concerning a public official or a private person. And then the publishing of the statement, so the actual defamation, causes damages. It hurts somebody, in other words. Okay, well, let me just make sure okay. So I wanted to make sure that you guys had some publicly available resources, just so that you know that, like, I've gone over a lot of information, and I know it's kind of dense. And so I want to make sure that you know where you can look online for basically, like, real information. So for trademarks and patents, the United States Patent and Trademark Office, USPTO.gov, that's your primary resource. They have a lot of material that is meant primarily for just, you know, regular citizens, i.e. not attorneys, to explain what a trademark is, what a patent is, how you get these things. Copyright.gov, that's going to be your source for copyright information in the United States. Cornell's Law School actually has law.cornell.edu. They basically republish the United States Code and the United States Code of Federal Regulations. Here in Florida, we have laws.fl, you can read it. And then you can also search, and I do this myself sometimes. I mean, I search like YouTube for like instructional videos on certain topics that I'm not familiar with. I will, Google. You can now, use any of your favorite AI tools to find information. I just want to say, be warned, especially with AI tools, the information that might get pulled is not oftentimes reliable, or it's not like 100% reliable. It could be old, it could be incomplete, and then occasionally with AI, it could sound like it's right and just be like way, way, way wrong. And I have no idea why that happens. And I do, like, I practice in this field, so I will periodically just like check and double check and get like ideas about certain things. And so I'm looking at stuff that I have a pretty good idea about, and I know sources where I can double check things. And I'm amazed by like all the incorrect information. So stick with these things primarily, and then, feel free to branch out a little bit, but, be careful. And now I just want to open it up to questions.
A couple slides back, you had something about being public. So let's say it's a famous person in public.
Yeah.
And I'm a photographer, and I just walk around the beach, all of a sudden I see somebody, snap their picture, I upload it on my website, I have a big following, it increases traffic. So inadvertently, I'm kind of profiting off that photo.
Yep.
That's a problem.
Yeah, so good question, because that happens an awful lot. So an important thing to understand is that a certain thing, like a photograph, it can actually have different types of intellectual property or other rights in it. And so you might have rights to some of that, and then you might not have rights to other types of intellectual property that's actually in that, like, say, photo. So in your example, which is a great one, you snapped the photograph. So you actually have the copyright in the photograph. So that's good. You got the copyright in the photograph. Let's say that the person that, like, you snapped, like you're at the beach, you snapped a picture of a person, and that person is like fully identifiable, like, you know, you see that person's face, for instance. You don't have that person's, like, you don't have that person's consent, and that person has a right of publicity. And so if they found out about that, they could send you a letter that's oftentimes called a cease and desist letter, where they could basically say, take that down. So the way we deal with this, because I write these all the time, they're not super complicated documents, is you get what's called a release or a model release. So, like, you know, if you wanted to take someone's picture at a beach, you would basically just have like a release. You'd say, you know, Madam or Sir, I'd really like to take your photo. It's going to show up on my, you know, I'm a photographer. It's going to show up on my blah 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 website. Is that okay? They're going to say yes. Sign it. You keep that. Now you got to keep the release, but then you can take the photo and you're pretty much good to go. Another thing that does trip up people, and again I keep on bringing up like social media, because this is how, by the way, most people like inadvertently violate other people's intellectual property rights. Buildings can be copyrighted. The actual designs of buildings. Now, a general like box, like just a generic building that's just like doesn't have an awful lot of like, you know, particular design aspects or features, probably not copyrightable. But if you think about some of the buildings that are going up in like downtown Miami now that have some kind of like, you know, I would just call them like artistic design, those are copyrightable. Statues are like a huge, like, so new statues, they're copyrightable. And so when people take like a photo in front of like a statue, if it's like for your own personal use, like no one cares. But if you're like a photographer and you put that up, or you blow it up and you like sell your photography like in a gallery, it's possible that the owner of that building, which is probably going to be the copyright owner, but it could be the architect who designed the building, could come after you. So this is why, if you've ever heard about with movies having to get cleared, or movies not being able to get certain scenes cleared, what it's talking about is a lawyer like me goes through the movie, watches the movie in effect, sees that there are certain things that are protectable, and goes, oh, did we get, you know, so-and-so's consent to show that? And people are like, oh, I don't think so. And then, you know, you have to go and get so-and-so's consent. Yes?
So you mentioned a lot that you work with like different United States offices and government departments. How many people, or I should say, how often do you come into contact one-on-one with public administrators within your line of work?
Oh, within my line of work, so come into contact is, so I'll say this. When it comes to coming into contact, if you mean by like email and phone calls, fairly regularly. A lot of ways that at the USPTO, a trademark attorney who is examining a trademark registration will they have like one concern, and they're like, if you do X, I don't have that concern anymore, and I can allow your registration to go through. They will oftentimes email you, and then they want an email back saying like, you know, you accede to it, you agreed, you know, you're going to do X, Y, and Z, and now for the purposes of getting my registration allowed. Same thing happens on the patent side. You have they're called it's not very creative or original, but patent examiner interviews. And that's where I just talk to a patent examiner and I say, I know that you said that we couldn't get, you know, this thing allowed with this, but how about if I change that word to like that? And, you know, they're like, no. And it's like, well, but think about it this way. And it's like, okay, I'll think about it. Yeah, so that comes up pretty regularly at the USPTO on both the trademark and the patent side. At the Copyright Office, a copyright registration really is more just there's a form, you have to fill out the form. If you fill out the form, it's registered. There isn't examination in the same way that the trademark examiner examines a registration for or an application for a trademark registration, or on the patent side, it takes several years typically to get a patent application allowed and issued as a patent. And so there's a lot of back and forth in that regard. So yeah, so like, but these people are like available. It's just I don't fly up every time I need to talk to somebody to Washington D.C., which is great because I don't really want to go up to Washington D.C. Yes.
I was always curious, how does copyright work for like conventions where people sell and make fan art for, I guess, trademark series and things like that?
Okay, good. Yeah, yeah, good question. So like fan fiction, all that type of stuff.
Books, shootings, all that fun jazz that you get at conventions.
Yeah, yeah, okay. So I don't want to like, because I don't want to make like a bigger deal out of this than it is. But anytime that like somebody takes, you know, like fan fiction or they create their own like, you know, maybe like drawing or painting based off of like characters that are in like a series or something, that would be called like a derivative work. And several slides back, I put up like all the things that you get when you have a copyright in something. And so like if you make your own original drawing of like Batman and he's doing something, you just made a derivative work off of a character that is owned by DC, like the intellectual property in that character is owned by, you know, DC Comics. And so you have violated their like, their
So they
copyright.
can come after people they felt like.
They could. The bottom line is, you know, are they interested in going after all of their fans that just really like Batman?
Yeah.
No. Are they interested in going after somebody like, let's say, like in, I'm just.
A rival company who makes a knockoff of it.
Right. Or imagine this. Imagine if you're, because you're just like a really good illustrator, a really good drawing. You just have like a great mind for that type of thing. Imagine if you like not just sell like one or two at like Beyond Comicon, but you set up a website and you sell like 10,000 a month. That will draw their attention. Doesn't matter how big a fan of Batman you are.
Is that high?
Yeah, it really is. It's like that, yes. I mean, they want a piece of that pie. Also, one of the things I don't emphasize this a lot in a lot of my like, a lot of presentations I give, but I also give presentations to like groups of artists. One of the things that it goes beyond the commercial aspect of like, I just want to make money. You as the creator of a work, you get to decide how that work is used. And the bottom line, like J.K. Rowling is a better example of this because she obviously wrote all those books and she's still around. You know, she gets to decide how Harry Potter is displayed. She gets to decide what kind of stories get to be told about Harry Potter. And somebody might offer her a lot of money and she might just turn it down because she just doesn't like the story or she doesn't like how Harry Potter's portrayed or anything like that. So the money is a huge part of it, but also just the fact that it's your creation so you get to decide also is a huge factor, especially in copyright law, but it factors into all types of intellectual property law. But yeah, it's a good question. Yes?
A few slides ago you had as well when you have multiple creators involved in a
Yes.
project. For example, a good friend of mine, he actually does video gaming.
Yep.
And there's like 8 people working on the game. So my question would be, obviously they're going to want to trademark and copyright it, but should there be like one main guy and they
Yeah.
figure that out? So
Yeah. So here's because this happens. So again, my background is I have a background in electrical and computer engineering, and so I deal with a lot of like tech companies and startups, and it's the same. The video game example is a perfect example, but it happens on the purely creative side too. What I tell everyone is, you and your buddies are coming together. You're doing something important. So what you do is you basically found a company. It can be a Florida LLC. You know, it doesn't have to be a corporation or whatever. Florida LLC. You got to work it out yourselves, but like the logical thing, if it's like 8 guys and they're contributing equally, you know, everyone owns an eighth of the company. And then what you do is you have an agreement between your new company, you know, I'll just call it NewCo, and each of the 8 people that transfers all of their intellectual property rights from themselves to the company. And then it's the company that now controls those rights. And it's going to be the company that's going to publish like the video game through like the App Store and through Google Play and put up the website. And also to the extent that like, you know, they're going to need to like hire other people, other services, it'll be the company that does that. And then here's the most important thing. This is like one of the things is it's just helpful to have all of the rights in one central entity, this LLC. The next thing though is that if something bad happens or if somebody wants to gets mad about the video game, they're gonna sue the LLC, not the 8 dudes or ladies, who knows. Yeah, and that's the real key. So LLC stands for Limited Liability Company. What that is the limited liability is that in effect, if you do things right, you could be the owner or part owner of an LLC. The LLC is being alleged to do something wrong. The LLC is the entity that has to show up in court. You may not be happy about your LLC getting sued, but it's not like you being sued personally. And so you have that protection. You have limited liability off of what the company did or alleged to have done. Yes?
One other question is, for comic artists, if you're publishing your own work, obviously you're not going to put everything in one go. Sometimes you'll do it by chapter. Is it better to register an LLC under your name? That way everything you make afterward just goes to that automatically?
Yeah.
Or do you just copyright, here's the title, and as it goes with that title?
So what I recommend for anybody who is pivoting from just, kind of sketching for themselves to, releasing, even if it's not primarily commercially to make money, maybe it's like you're just really passionate about it, but you are going to be like releasing it publicly and you're going to be maybe making a little bit of money off of it. At that point, what I always recommend is found a company, have the company control the internet domain, so it'll be the owner of the internet domain, have the company own the copyrights in the illustrations, and it would be your company, you'd be the 100% owner. And you would transfer the copyrights over to the company, and then it's the company that's going to be putting out the published work. So, and also if you decide to sell it, what people are going to be doing is they're going to be selling, or they're going to be buying copies or buying prints of your work, your comic book, from the company. Which again, if they're angry about something, it's the company's problem, not yours.
I'll talk to the boss about it.
Right.
Why did you do that?
Yes, it is kind of like that, but it has really really important and helpful legal protections for you. So I never overlook that. It's super easy, by the way. Sunbiz.org is the Florida Department of State. You can start an LLC very quickly for like $100, $140. I'm sorry, you had a.
Oh, that's okay. What would you recommend for if you have a design, it's like a base design, but you're kind of repurposing it for like different colors, like for example, I do cat stuff, so a lot of the times I'll do like a base design of something and then just like, based on what cat breed it is, they'll be different, but the shape is still the same. Like, how would you recommend registering? Would they be registered like individually or as a whole?
Yeah,
or?
no, I got you. I would say we'd have to take a little bit closer look, but because an individual copyright is on the order of like hundreds of dollars, which I know is not like cheap, but like for something important, you can spend the money. If you do it like 20 times over, now you're starting to talk about like serious money, So what I would recommend without knowing more about that is you'd really want to look at the base design, because under the idea of derivative works, it sounds like the base design is like the core work, and then you're creating variations of it, which would be protectable under the basically derivative works. That's what it sounds like to me.
Yeah.
What I oftentimes tell people, again, because this kind of shows up in different contexts. So, J.K. Rowling didn't just stop with like the Sorcerer's Stone. She has copyrights in all of the books and in many other things that she's written around like the world of Harry Potter and like her other things. So you got to make a decision between like what's like of like super importance, what's like kind of important, and then like what's like, if I had all the money in the world, yes, I would file a copyright on that. Super important stuff basically gets a copyright registration. The stuff that's in the middle, you'd look at like how much protection do my existing copyrights give me in that. And then, like I said, to the extent that you have additional money left over or something that you thought was like unimportant becomes important, then you basically go ahead and get the registration on it. Sometimes it is really like pretty straightforward. If you have like a really commercially successful, or if you have like a new design that is related to an old design, but it's going to be like, it's going to serve as like the centerpiece for like a whole new like campaign or a whole new series, then you would definitely get a registration on that. And this is like, again, going back to like comic book series or like, you know, books in a series, each book should get, you know, copyrighted. But again, especially if you're like an artist and you're generating an awful lot of content, you're gonna wanna, like I said, use those tiers and really focus on the stuff that's at the very top.
Even if they're used for physical goods?
Yeah, I mean, yeah, so I'm not gonna zip that all the way back, but copyrights, yeah, so you can get copyrights on like statues, copyrights on photographs, copyrights on novels, copyrights on paintings, copyrights on comic books, software. It's not the figurine that would be copyrighted, it's really like the design of the figurine, but yes, you can get, like, that's a statue in other words, I mean. Yes?
The books, when people are reading books, let's say online, they're protected, right, and should be, I guess, request permission from the author if they should read it.
I think
You know, let's say on YouTube, you got a book and you just want to read the book outline and read it from start to finish.
Okay, so that's it. Now you made the question pretty straightforward. So so there's a lot of copyright law about like Google Scholar, and they used to have like, they make excerpts of certain works available. There's also something I do want to point out that I talked about how long your copyright like lasts. After that, the word we use is that the work then is in the public domain. So like all the works of Shakespeare, because he was like 300 years ago, 400 years ago, whatever it was. His works are all in the public domain. You don't need anybody's authorization to basically read, you know, Romeo and Juliet in front of a camera and then post it to YouTube. That's just you. However, again, going back to like a copyrighted work, if you were to basically read it, or not you, but somebody else, and then post that to YouTube, that again falls under like the derivative work. And so there's a way, it's too much to get into, but there is this thing called the Digital Millennium Copyright Act, oftentimes just referred to as DMCA. And there is a takedown procedure which YouTube and all the other social networks use, where if like, again, if you read like Harry Potter, like one of the Harry Potter books, just like on YouTube, or if you even read like a chapter of it, that would be enough. You know, like J.K. Rowling has like an army of attorneys, and they would essentially file one of these takedown notices, and that would just pull it down. Chances are, if you did it once, and it's just like somebody like in their living room doing it, they would just notice that they would get a note from YouTube being like, you have taken down, like, we have taken down this video. There'd be like ways to appeal and stuff like that, but you wouldn't do that in this instance, and that would be the end of that. You know, if you did it like a lot, you know, you might get something more direct than just a takedown notice. But in general, that happens all the time. So this happens all the time on like YouTube is a perfect example of this, where YouTube used to be really bad about people would have whatever. They would do like, they basically make their own like music videos, or they'd make their own like show, and they'd have background music just like a television show would. And they wouldn't be paying anybody for that music, and YouTube would just let that happen. This is like years ago. And now YouTube is much more, you know, they're just much more focused on making sure that if they get a complaint from, in this case, like a musician or a publishing company, they pull it down right away. Any other questions? Yes?
How can somebody find you? You have a card?
Oh yeah, I'll be happy to hand out my card after this. Yeah, because I think I brought enough. Anybody else have any questions? Otherwise, oh, you have one.
Kevin, I got one.
Yeah.
If someone has a printed publication, book, magazine, and they have a digital version, like an ebook,
Yep.
would they need to have a separate copyright application?
Good question. So my general feelings about that is anything. Ooh, that's a good one. That's like a bit of an edge case, which means it kind of can go either way. What I would basically do is I would say if it's just an ebook, so you're not talking about like an audiobook, are
No,
you?
an ebook.
An ebook. I don't think that the ebook would need to be, there would be a separate copyright in that. But the audiobook, someone actually like, you know, reading it aloud, you're going to notice that there's going to be the book is going to have a copyright, and then the audiobook is going to have the copyright as well, or going to have a separate copyright. probably owned by the same company, but there'll have to be some relationship between the two. Otherwise, the audiobook is in effect a knockoff of the book. Does that answer your question?
Yeah.
Okay, cool. All right, if there's no, yeah, well, thank you so much. I really appreciate it.
Thank you.
Yeah.
Thank you. We're glad you came out.
Oh, yeah, well, I'm glad you guys, yeah, thank you so much.
And for the purpose of the camera, we'd like to let our viewers know how they can contact you for your
Oh,
services.
yeah, so my name is David Osteen once again, and I am of counsel at Asseline and Burlow, so I live and work in downtown Miami, and you can find me online at asselineandburlow.com, and for all of you that are in the audience, I'll be more than happy to give you my business card, and thank you so much.